divorce rate for people 50 and older doubled between 1990 and 2010. And according to the Institute for Family Studies, the divorce rate for people 65 and older was 15% as of 2022. Now, this demographic, commonly referred to as the gray or silver divorce, tends to face a variety of economic and emotional challenges when they're going through a divorce, including health battles such as Alzheimer's. According to the Mayo Clinic, most people with Alzheimer's are 65 and older, and that comes out to about 1 in 9 people that have the disease. June is known as Alzheimer's Awareness Month, and joining us to talk about how a diagnosis can impact a gray divorce is Sean Smith, member and co-founder of the Family Law Department at the New Jersey law firm of Brach Eichler. Sean also works with the New Jersey courts as a mediator, where he helps resolve difficult and complex family matters. Sean, welcome.
Well, thank you very much for having me.
Thank you for being here. Now, something you and I talked about, the gray divorce controls the greatest amount of wealth. It's also the demographic we're seeing the highest rates in those looking to dissolve their marriage. And it's crazy to think, because research tells us the overall divorce rate has declined. But based on your professional experience, why do we continue to see an uptick in the gray divorce category for the past 20 years?
It's a wonderful question with several different answers. 20 years ago or so, a lot of the uptick was really tied to what we saw in the industry as second marriages, where second marriages just generally have, second and third marriages generally have statistically higher failure rates because they marry later in life. They may have difficulty blending families, financial disagreements, or mismatched expectations. But what we're seeing now is a much greater trend of divorces with individuals. I refer them as gray divorces with individuals over the age of 55 who happen to be in marriages that are of a much longer basis. They may be married for 25 to 30 years, and historically that was not an area you saw a lot of divorces in, and those changes have really come about anecdotally and from what clients have talked to us about societal's changing attitudes towards divorce, that divorce has become more socially acceptable, that families found themselves in the empty nest situation, meaning that children had grown, became adults, and moved out, and they were in that empty nest situation for a much longer period of time, which ties into the longer life expectancy. And for often situations with women in particular are seeing financial independence, that this group of individuals previously may not have been in a financially secure situation where they had the ability to move out on their own. And as a result, what we've come across is a significant uptick on the gray divorce perspectives, because individuals are finding that they have the ability to support themselves as an individual in the retirement years. And that's, from our perspective, anecdotally, and our experience is what we've seen.
June is also Alzheimer's Awareness Month, and as I mentioned in the open, most people are diagnosed with Alzheimer's around the age of 65, which is the gray divorce range, which is what we are talking about. If one of the parties in a divorce is diagnosed with Alzheimer's, how can this complicate the process?
It's a great question. It really depends. It depends on when the diagnosis takes place. Is it something that has been an ongoing mental health issue within the family with diminished capacity, or is it something that is driving the divorce, meaning the individual may or may not have been diagnosed specifically with Alzheimer's, or they may have been diagnosed in that early onset, but that their personality's changed? And how is that impacting their ability to make decisions? How is it impacting their ability to be a spouse? And are they the one that's seeking the divorce versus the one that is sort of what I would describe as the defendant, the person who's not necessarily asking for the divorce? From a complication perspective, it's going to depend ultimately on the individual's mental capacity. If it's at the early onset stages where the individual can make decisions about their person, their property, and how they want to handle the divorce process, it might have a smaller impact, where you might be focusing more on what's it going to look like in 10 years for this individual. How do we create a situation where the individual who's been diagnosed is in a financially secure spot where they may be able to take care of their long-term health care. But if it's a different situation where the person is been diagnosed and has had long-term issues and is now in the full throes of Alzheimer's or any other cognitive diminished capacity, the process for the divorce is greatly complicated. We find ourselves in a situation where you may have a party who may not be able to handle their own affairs, may not be able to make decisions, and we walk into an environment where everyone involved in the proceeding is trying to come up with a solution that provides for both the person who's been diagnosed with Alzheimer's, but also the person who is not. And where it becomes very complicated is how do we deal with the long-term health issues, and how do we also deal with the family's marital estate. As you mentioned in your opening, this generation right now is carrying with it the largest amount of wealth, and as a result, when we're dealing with gray divorces, particularly if it's their first marriage, we're often dealing with the distribution of very significant assets that when you're dealing with somebody with Alzheimer's or any other significant diminished capacity situation, we're focused on how do we take care of everybody. The person, the humanity in me says we have to focus on the person with Alzheimer's, but we're also at the same time we have to remind ourselves that there's another spouse who is going to now need to live their own life outside of the marriage, away from the person with Alzheimer's, who was a part of the marital enterprise that created the wealth. And those types of situations result in very often very complicated proceedings from a legal perspective involving potentially guardianships, guardian ad litem appointed by the court to provide us with information as to what's in the best interest of the individual, to separate attorneys, to very creative estate and tax planners to help us create a financial circumstance that allows for the family to get to the next stage, which is the marriage is dissolved and both parties are able to move forward with their life.
What if the party who is diagnosed with Alzheimer's is responsible for alimony? In New Jersey, where you practice, are they still legally required to satisfy these monthly payments and, depending on their age, possibly Social Security benefits, assuming the other side has not remarried?
It's a great question with quite a few nice subsets. First, Social Security benefits. If the parties have been married for more than 10 years, the Social Security benefits of the parties will not necessarily be impacted by divorce. Both parties will be entitled to their Social Security, whether there is or is not a divorce. But in terms of the question relating to alimony and being responsible for payments of alimony, the answer is it depends. If the individual was a W-2 employee, and as a result of their diminished capacity through Alzheimer's, they no longer are employable, that would give rise to what is known as a change in circumstances for that person's employment status. Certainly if they are declared disabled by Social Security, we have presumptions of an inability to work. And you would see that the alimony obligations that were tied to the person's income and earning capabilities would likely be modified, if not suspended and or terminated. But it really depends on how it impacts their ability to work. That being said, if the individual is an owner of a business and the business continues to operate and it continues to distribute K-1 income or other compensation to the individual with Alzheimer's, where their income itself doesn't change, it's unlikely that you're going to see a change in the alimony obligations. And again, we're talking about individuals on that gray divorce, in that gray divorce period where, the accumulation of wealth has already taken place and they're much further along in their lives. So you may have situations where that individual is no longer required to show up to work to make their money. The business is an ongoing enterprise, and it continues to distribute the necessary funds to provide the support to the party receiving alimony. And if you remember, just in general, alimony, the concept of alimony or spousal maintenance is to provide the non-supported or the non-moneyed spouse, meaning the supported spouse with sufficient income to live at or around the marital lifestyle that they enjoyed while they were married. So you don't want to be in a situation where you're cutting that person out unless there's a change in the other person's or the responsible party's actual income.
You had mentioned before that when you're dissolving a marriage that is a great divorce and one of the parties has been diagnosed with Alzheimer's, a lot of other professionals can be brought into the picture. Guardian ad litem, power of attorney, trust and estates attorney. In these situations, can these marriages be dissolved out of court and without the need for a judge?
Well, it's a good question, and from my perspective, and I did a little bit of research on this, I can't find a single jurisdiction in the United States that would allow for a marriage to be legally dissolved without a judicial order. So ultimately, a judge will have to put the court stamp of approval on a judgment of divorce to dissolve the actual legal marriage. But more importantly, as a practitioner or as a family member or a party that's involved in a divorce where you have somebody with Alzheimer's or other diminished capacity, I would strongly suggest you involve the court as much as possible because there is not a lot of guidance on how to resolve these types of matters from a case law perspective. They are very fact specific, and they do require creativity on the part of all of the parties involved, from the individuals who are going through the divorce, perhaps from their family members, perhaps input from their previous estate attorneys on how they've structured their estate planning and tax planning, and how do we unwind this and provide both parties with sufficient assets and or income so that they can move on to the next stage of their life. And why you want to have the court involved from the beginning is you don't want to get through this process all the way to the end and have a judge say, I appreciate everything you've done, but I can't approve this under our state's laws. So by bringing the court in at the beginning and involving the professionals from the beginning, the parties have a much better opportunity at creating something from a resolution perspective that ultimately provides for both the individual party with diminished capacity, through whether it's Alzheimer's or another illness, but also through the other spouse who's moving on with their life. And I think without that involvement, parties really do run the risk of unnecessary delay, unnecessary expense, and those types of issues. So using a judge from the beginning is a strong recommendation.
Sean, for people who want to learn more about this, how do they get in touch with you?
My name is Sean Smith, SEAN, I can be reached at 973-364-5216, or you can email me at ssmith@Brach-Eichler, BRACHEICHLER.com.
When life takes an unexpected turn, whether it's marriage, divorce, custody issues, or planning for the future, you need more than a lawyer. You need a team that understands the emotional weight behind every legal decision. That's why so many families turn to Brach Eichler. Their experienced attorneys combine deep legal knowledge with compassion and strategy, guiding clients through sensitive situations with clarity and confidence. Whether you're facing divorce, child custody, support, prenups, post-judgment modifications, or complex asset division, Brach Eichler brings top-tier talent from across the firm. From estate planning and tax to business and real estate, they provide comprehensive, cost-conscious solutions tailored to your unique situation. With offices in Roseland, New Jersey, New York City, and West Palm Beach, Florida, Brach Eichler is ready to help wherever life takes you. Proven results, personalized strategy, unmatched integrity. Visit BrachEichler.com to learn more about their family law services or to schedule a confidential consultation. BrachEichler.com. That's BrachEichler.com. BrachEichler.com.
This is intended to provide general information, not legal advice. Please contact Sean if you need specific legal advice. Results may vary depending on your particular facts and legal circumstances.